For those of you who don't know me, I am a barrister specialising in public, local government law and housing law at Cornerstone Barristers, and I have a particular interest and specialism in licensing the private renter sector under the Housing Act 2004. This, as I say, is the second in a series of 4 webinars. The first of them last week looked at licensing designations. Next week we'll look at licenses and license conditions. And in the 4th and final webinar, we'll take a look at aspects of enforcement, in particular aspects of prosecuting and penalising licensing offences. But for today's purposes, what can you expect from this webinar? Well, as many of you will know, specifying application requirements and setting application fees, whether under Part 2 or Part 3 of the Housing Act 2004, can be a complex and is often quite a vexed process, which tends to raise numerous different legal issues. And I'm frequently instructed during the course of a local authority preparing to designate an area as subject to either additional HMO or selective licensing to advise on a range of issues. And they include the likes of what application requirements can a local housing authority lawfully specify when it creates its application process? When is an application duly made for the purposes of Parts 2 and 3? And we'll come on to that a bit later on. What happens if the local authority doesn't determine an application within a reasonable time? What are the consequences of that? What fee structure should the local housing authority adopt? And this is an issue that frequently recurs and about which I'm asked to express a view. And what costs can local housing authorities lawfully take into consideration when setting their licence fees? So, as I say, these are some of the most common issues that I tend to encounter in my work for local authorities, and which will indeed provide the focus of this webinar. So we will, as indicated on the slide, be looking at some very specific, commonly encountered issues. This won't be a general topic overview, although some overview about these particular issues will be given. And it will not look at the process of determining applications. So, for example, at the issues of fitness and propriety. Rather, we will look at application requirements and fees. And as indicated last week, any views expressed during this webinar series are expressed for educational and not advisory purposes. So if you do require assistance with any of the issues that we will discuss today, my recommendation is that you seek separate legal advice. And you are welcome, of course, to return to me for that. If you have any queries about this particular webinar, or indeed anything regarding licensing, then feel free to drop me an email at dunderwood@cornerstonebarristers.com. So we will divide this webinar into 2 sections. The first will look at application requirements generally, and the second will look more specifically at fee setting and fee structures. So where do we start? Well, application requirements are provided for in sections 63 for the purposes of Part 2 and section 87 for the purposes of Part 3 of the 2004 Act, which confer on local housing authorities a wide discretion to specify application requirements, including a discretion to fix and require the payment of a fee. In terms, the sections provide that the licence application must be made in accordance with such requirements as the authority may specify, and that the authority may in particular require the application to be accompanied by a fee fixed by the authority. Now, while that general provision is only subject in the 2004 Act to a further provision that says it is subject to regulations made by the Secretary of State, or in Wales, the Welsh Assembly, which we'll come on to in a moment, there is nothing in the provisions themselves that tends to limit the way in which that particular discretion may be exercised. While the discretion afforded by sections 63 and 87 is wide, however, it is nonetheless not unfettered, as the slide indicates, and is subject to various legal requirements and considerations. So Generally, of course, it will be, because the local authority is a public authority exercising public law functions, it will be subject to the principles of public and administrative law generally. So, for example, the requirements that a local authority specifies for the purposes of its application process will have to be rational. And of course, they will have to fall within the scope of the authority's statutory powers to specify them. They cannot, as lawyers say, be ultra vires. Secondly, the discretion has to be exercised in accordance with generally applicable statutory obligations and duties. So, for example, those under the Equality Act 2010. Taking the 2010 Act as an example, the requirements, therefore, cannot discriminate against an applicant by reason of a protected characteristic, such as a disability or age. And the authority must, when requirement setting, comply with the public sector equality duty when specifying its requirements. And for those who need a reminder as to what the public sector equality duty is, I'll read it out very quickly. Under section 149 of the 2010 Act, a public authority must, in the exercise of its functions, of which of course parts 2 and part 3 are functions, have due regard to the need to eliminate discrimination, harassment, victimization, and any other conduct that is prohibited by or under this Act, advance equality of opportunity between persons who share a relevant protected characteristic and those who don't, and foster good relations between persons who share a relevant protected characteristic and those who do not share it. And of course, disability and age are just two of a number of protected characteristics under the Act. Moving away from the public sector equality duty and turning back to issues of discrimination, just to give you an illustration of how this might apply, a requirement specifying, for example, without any exception or mitigation, that all applications must be made online would arguably discriminate against those who are unable to use a computer because of a disability, or discriminate indirectly perhaps against the elderly, who may not have as ready access to online facilities by reason of their age. So, as I say, generally applicable statutory obligations must also be observed. The discretion must also be exercised in accordance with the authority's general 2004 Act duties, of which there are a number under the 2004 Act, for which see, for example, sections 55, 61, 79 and 85. So perhaps most relevantly, the first of those is to make such arrangements as are necessary to secure the effective implementation of Part 2 and 3 licensing regimes. So the requirements that a local authority sets when designing its application process must help to fulfill that statutory obligation. There are other general duties, perhaps not quite as relevant, to take all reasonable steps to secure that license applications are made and to ensure that applications and other issues are determined within a reasonable time. Further, as indicated at the start of this slide, sections 63 and 87, the discretion is also subject to any regulations that the Secretary of State or the Welsh Assembly might make about its exercise, and we'll come on to that discretion in a moment. And then lastly, as a result of the Administrative Court's decision in the case of Gaskin, that's the 2018 as opposed to the 2017 decision, because there are two, it's also subject to the provision of Services Regulations 2009. And again, we'll come on to that separately in a moment. Let's deal first of all with regulations under the 2004 Act. And forgive me, because this is a potentially dry subject, but I'll go through it nonetheless because it is important. Regulations that are made under the 2004 Act prescribe various requirements about the form and content of license applications, and they can be found in the licensing and management of houses in multiple occupation and other houses miscellaneous provisions, England, or as the case may be, Wales Regulations 2006. And as you will have noticed under the 2004 Act, it's an absolute prerequisite that any statutory instrument that is made is very snappily entitled and not at all a mouthful to speak about. The requirements differ according to whether a property is in England or Wales, and if it's in England, whether or not the application is a so-called renewal application, and more on that in a moment. I don't intend to go through the prescribed requirements in any detail for fear either of losing you or sending you to sleep in the heat. As I say, that they are a little bit dry, but for present purposes, I would ask that you take it from me that generally they're intended to ensure that local authorities have sufficient and accurate information about, for example, the property, the applicant, its owners, managers, occupiers, facilities, etc., to determine the license application. And indeed that those affected by it, including the owners, occupiers, but third parties such as mortgagees are aware of the application. Now, regulations made for the purposes of Wales do not distinguish between renewal applications and other types of applications. So applicants requiring a license for a property in Wales are required to provide all of the information prescribed by the 2006 regulations in any second or subsequent application in the same way as they did in their first. By contrast, the information required of renewal applicants in England is limited, and an authority cannot lawfully require them to provide more. And the authority for that proposition is found in the first of the Gaskin cases, the 2017 case, in Lord Justice Bean's judgment. I'm just going to take a moment to read the relevant paragraphs of that because they are potentially salutary. So paragraph 36 and 7, Lord Justice Bean says as follows: Section 63, subsection 6c provides that such regulations may specify the information which is to be supplied in connection with applications. The use of the definite article is highly significant. The words specify the information which is to be supplied mean that it is only those items of information listed in the regulations whose provision can be made mandatory by the local housing authority. The list, in other words, is a maximum, not a minimum. Following the amendment made in 2012, the regulations no longer require occupants to be named on a renewal application, and accordingly the council's insistence on the provision of that information before renewal was unlawful. He goes on, however, to say, and this we may look at this again later on in the presentation, there would be nothing wrong, however, with an application form inviting the landlord to give names on a renewal application, so long as it is made clear that this is voluntary. We should also emphasise there's nothing unlawful in our view in requiring the applicant landlord to sign a declaration, as Mr. Gaskin did in the present case, as to whether there's been any material change in the information submitted to the housing authority since the previous grant of a licence. So what you cannot do, therefore, is require a renewal applicant to provide any more information than is prescribed by the 2006 regulations if you are an authority in England. What, you may ask, is a renewal application? Well, for the purposes of authorities in England, a renewal application is defined in Regulation 7, subreg 11, as an application for a licence which is made at a time when a licence of the kind applied for is already held by the applicant and has effect in respect of the house in multiple occupation, or as the case may be, the house. A couple of important points to note about that particular definition. So on the face of it, it doesn't include an application for a licence that is made after a previous licence has expired or has been revoked, nor does it include on the face of it an application for a licence under a different part of the 2004 Act in respect of the same property. So for example, if someone were to apply for a licence under Part 2, having previously applied under Part 3, that would not, it seems, be a renewal application. So moving on from regulations under the 2004 Act, let's take a look at the provision of service regulations 2009. So as indicated previously, the exercise of the section 63 and 87 discretion is also subject to the provision of services regulations 2009, which give effect in domestic law to the EU Services Directive. The EU Services Directive contains provisions for, and I quote, facilitating the exercise of the freedom of establishment for service providers and the free movement of services. For the avoidance of doubts, those regulations remained in force despite the UK's departure from the European Union. In their material parts, the regulations make provisions in respect of so-called authorization schemes, and they impose certain obligations and prohibitions on the competent authorities, again in inverted commas, that administer them. Why, therefore, I hear you ask, do they affect local housing authorities which administer licensing designations under Parts 2 and 3 of the 2004 Act? Well, in brief, in the second of the Gaskin cases, the 2018 case, the Administrative Court held that the regulations applied to the licensing schemes enacted by Part 2, in that case, and therefore by extension, Part 3 of the 2004 Act. Because in principle and in summary, the letting and managing of a property for a profit was held to be a service within the meaning of the regulations. The local authorities that administer the licensing schemes and regulate the properties were held to be competent authorities, and the licensing provisions of Part 2 and again by extension Part 3 were held to be an authorization scheme within the meaning of the regulations. So the result was that provisions such as those enacted by Regulation 18 of the 2009 regulations applied to Parts 2 and 3 of the 2004 Act. And materially, Regulation 18 Subreg 4 in particular prevented the local housing authority, in that case, of course that was Richmond, from requiring the payment of a so-called Part B fee at the point of application. That is, from requiring the payment of a fee at the point of application that covered anything other than the costs of processing the application. And as I say, we'll look at fees in a little more detail a bit later on. Now, that was the limit of the Administrative Court's decision in Gaskin. But query, does the decision have potentially wider implications for local housing authorities? Well, I would suggest so. So by Regulation 18 of the 2009 regulations, the procedures and formalities of an authorization scheme must also be clear. They must be easily accessible. They must be made public in advance. And importantly, perhaps, they should not be dissuasive nor unduly complicate nor delay the letting of property. In the words of the legislation, the provision of the service. So again, query, does this require local authorities, where necessary, to streamline their application process to avoid, for example, unnecessary duplication in the provision of information or to reduce delays in the application process? Well, there's no direct authority on point, and Gaskin certainly doesn't deal with this directly, but arguably so. And given that Regulation 18 was held to apply in Gaskin by virtue of, as I say, Mr. Gaskin being a service provider and the local authority being a competent authority. And in any event, I would suggest local authorities would be well advised to streamline their application process wherever possible for the purposes of good administration and indeed for their own benefit, and many, of course, already do so. But moving beyond Regulation 18, Regulation 19 provides, in essence, for an enhanced duty to ensure the determination of license applications within a reasonable time, and for so-called tacit consent to the application in default. Now, you'll recall, if I flick back to the previous slides that one of the general duties under the 2004 Act on local housing authorities is to ensure that applications and other issues under the 2004 Act are determined within a reasonable time. As I say, Regulation 19, assuming it applies, arguably extends that duty further. And I'm going to read out for you the relevant parts of Regulation 19 to put you in the picture and to give you some context. So under Regulation 19, authorization procedures and formalities provided for by a competent authority under an authorization scheme must secure that applications for authorization are processed as quickly as possible, and in any event within a reasonable period running from the time when all documentation has been submitted. That period must be fixed and made public in advance. In the event of a failure to process the application within the period set or extended in accordance with the preceding provisions of this regulation, authorization is deemed to have been granted by a competent authority unless different arrangements are in place. And then lastly, any different arrangements must be justified by overriding reasons relating to the public interest, including a legitimate interest of third parties. So, does this effectively result in the grant of a license in default of a timely determination of the application? Well, again, there is no authority directly on point, certainly not under the 2004 Act, but again, arguably so. And indeed, to safeguard against the prospect that it does have that effect, it has prompted local authorities nationwide, sensibly, I would suggest, to make provision and settle policies that disapply the tacit consent provisions by making so-called different arrangements for, again in inverted commas, overriding reasons of public interest. Now, some of those who have done so have indeed made different arrangements, and I would suggest are required to do so. So, for example, where an application has not been determined within a period of, let's say, 10 weeks, they provide the applicant with the right to request that their application be referred to a manager. And if the manager hasn't then determined it within a reasonable period, that they can refer it to the head of service, or, for example, use the internal complaints procedure. And those are examples of the types of different arrangements that are put in place for ensuring that an application can be processed and that an applicant has some redress. As for overriding reasons of public interest, well, the reasons frequently cited by those who make policies to this effect are that one of the purposes, and the important purposes, of licensing under the 2004 Act is to ensure that those who have control of and manage licensed premises are fit and proper to do so, and that the tacit consent provisions would enable potentially the grant of a license without that determination having been made, and that, they argue, would be contrary to the public interest and indeed contrary to the interests of third parties, including the public generally. And indeed, when it comes to houses in multiple occupation in particular, one of the requirements is that the local authority is satisfied that the house is suitable for occupation by a particular number of people, and that its management arrangements are adequate. And again, because of the risk that HMOs are deemed to pose to their occupants and members of the public because of the potential for hazards, it would again, it's said, be contrary to the public interest to have that license application determined by default as opposed to by a proper due process with the local authority. And so that probably is in my respectful view, is probably a sensible way of dealing with the tacit consent provisions until we get some authority on how they actually apply to the licensing regimes under parts 2 and 3 of the 2004 Act. Well, enough about the Provision of Services Regulations 2009 for the moment. Let me say something before we look at fees more particularly about application requirements and the duly made application. Bear with me while I move you to the relevant slide. So section 63 for the purposes of part 2 and sections 87 for the purposes of part 3 provide that license applications must be made in accordance with such requirements as the local housing authority may specify, and that local authorities may in particular require the application to be accompanied by a fee. And in this context, certainly in the context of licensing enforcement, a question often arises, therefore, as to when an application is duly made. And the reason for that is that the enforcement provisions, in particular sections 72 subsection 4 and 95 subsection 3 in respect of parts 2 and 3 respectively, provide as follows: in proceedings against the person for an offence under subsection 1, that is for having control of or managing an unlicensed house in multiple occupation or house, it is a defence that at the material time an application for a licence had been duly made in respect of the house under whether it be section 63 or 87, and that application was still effective. All of which, of course, begs the question, well, when is an application duly made? Well, typically, perhaps there's no authority directly on point under the 2004 Act, but arguably local authorities might find some assistance in the case of Middlesex County Council and the Minister of Local Government and Planning in the judgment of Lord Justice Somerville, in particular, page 18. That case concerned whether a local authority's objection to a compulsory purchase order had been duly made as required by the relevant legislation. And in Lord Justice Somerville's judgment, the words duly made mean made within the time fixed. He goes on to say they may mean other things, the prescribed form and so on, if there is one, but they undoubtedly, in my opinion, mean that. What does that mean? Well, typically the answer is arguable, but it might well be said to mean that an application is not duly made unless and until it is made in full accordance with the requirements specified by an authority in the lawful exercise of its discretion under sections 63 and 87. And that is certainly how many local authorities interpret the expression. It remains to be seen whether that's correct. Again, as I say, there's no authority directly on point under the 2004 Act, or whether, for example, in criminal proceedings in particular, the court would be inclined to give a defendant greater latitude by defining the expression a bit more liberally. But as I say, we will have to wait on a suitable case for that issue to be determined. So that's all I propose to say for the time being about application requirements generally. Let's move on to take a look at fees and fee structures more particularly. So as you've heard and by now will know, sections 63 for part 2 and 87 for part 3 provide that local housing authorities may in particular require an application to be accompanied by a fee. Materially, they also provide in subsection 7 that when fixing fees, local housing authorities may, subject to regulations, take into account, first of all costs incurred by them in carrying out their functions under part 2, or as may be part 3 of the 2004 Act, and all costs incurred by them in carrying out their functions under chapter 1 of part 4, that is in respect of interim and final management orders in relation to either houses in multiple occupation or, as the case may be, part 3 houses, so far as those costs are not recoverable under chapter 1 of part 4. Now, we'll return to the scope or the potential scope of these provisions in a short while. But for the time being, note again that the local housing authority's fee setting discretion under sections 63 and 87 Although wide, is again not unfettered and is subject to, as we saw previously, principles of public and administrative law generally, to regulations made by the Secretary of State or the Welsh Assembly, to the provision of services regulations, and indeed to more generally applicable statutory obligations such as those under the Equality Act 2010. Now, I'll say more about both sets of regulations, those made under the 2004 Act and the 2009 regulations, in a moment. Before I do so, importantly, it's important to note local housing authorities may not set their fees so as to make a profit from their licensing schemes or designations. And the authority for that, although it is, I think, obiter, is to be found in the first of the Gaskin decisions, 2017, paragraph 32, and I'll read that out for you. Again, this is in the judgment of Lord Justice Bean, a typically erudite judgment. Section 63, subsection 7, expressly permits the council in fixing fees under section 63 to take into account all costs incurred in carrying out their functions under the relevant part of the 2004 Act. It cannot make a profit from the fees in the sense of levying more from HMO licence applicants than is required to cover the overall cost of these functions, but it is not unlawful to charge the same for a renewal application as for a first application. So the licensing schemes designations made under parts 2 and 3 must in effect be cost neutral. That, of course, does make fee setting, which is done initially well in advance of designation, a rather invidious and difficult exercise, and to a certain extent one of real crystal ball gazing. And it's sometimes the reason why authorities look to revisit their fees partway through a licensing designation. And I know one or more of you have asked a question about this, to which I'll return at the end of the presentation. In the meantime, let's take a quick look at regulations that are made under the 2004 Act, because you'll recall that the fee setting discretion is expressly subject to such regulations as the Secretary of State, or as the case may be, the Welsh Assembly might make. So the Secretary of State and the Welsh Assembly, they have both regulated about fee setting, but only to a limited extent, and only to specify cases in which fees have to be refunded. And you'll find the relevant provisions in Regulation 7 of the 2006 regulations as they apply either to Wales or, as the case may be, England. So in brief, local housing authorities must refund in full any fee that is paid in respect of an application as soon as reasonably practicable after they learn that at the time the fee was paid, a house was not, in the case of an application under Part 2, a house in multiple occupation, or an HMO that was required to be licensed. Or in the case of an application under Part 3, the house was not required to be licensed under Part 2 or Part 3 of the 2004 Act. So there is an obligation in those cases to return the fee that is paid. And local housing authorities are obliged to refund an applicant whether or not, as a result of the application, they granted a license for the HMO or house when it wasn't in fact required to be licensed. But apart from that, there are no other regulations under the 2004 Act, at least, about license fee setting. The regulations which, however, will concern and possibly vex local housing authorities a little more are the 2009 regulations. Before I come on to those, let's take a quick look at the costs which, under the provisions of the 2004 Act itself, a local authority might properly take into account. So if I just take you back a slide or two, you'll remember that under sections 63 and 87, when fixing fees, local housing authorities may take into account all costs incurred carrying out functions under Part 2 or Part 3, and those carrying out their functions under Chapter 1 of Part 4, insofar as they're not recoverable under that chapter. Well, what does that enable local housing authorities to take into account? Well, arguably, I would suggest the discretion, if not probably, is wide enough to enable local authorities to take into account the costs of the following, for example. First of all, of satisfying themselves that conditions for a licensing designation are met. That is, after all, one of the functions for which parts 2 and 3 provide under sections 56 and 80. The costs of consulting about a proposed designation, again, a function under parts 2 and 3. In England, where necessary, seeking ministerial confirmation. And I said in England there because if you were with me for last week's webinar, you'll know that in Wales, ministerial, or rather the Welsh Assembly's confirmation is generally not required because of general approvals that the Welsh Assembly has given. Of fulfilling general duties under the 2004 Act, for example, to secure the effective implementation of licensing or to secure that applications and other issues are determined within a reasonable time, for satisfying themselves that the conditions to the grant of a license are met, for example, that a person is fit and proper to hold a license, or that the management arrangements for a house or HMO are adequate, or that an HMO is suitable for occupation by the proposed number of people in the license application. The costs of varying and revoking licenses, reviewing the operation of licensing designations, investigating, prosecuting and penalising offences, and applying for and obtaining rent repayment orders. Now, all of these are arguably, if not probably, functions under Part 2 and or Part 3 of the 2004 Act, to say nothing of the functions, of course, to which the Act refers under Chapter 1 of Part 4. But importantly, and this is where the issue becomes a little more tricky, not all of those costs can be taken into account when fixing the fee that is charged to an applicant at the point of application. And the reason for that takes us back to the 2009 regulations, to which we now turn. So why is that the case? Well, because in Gaskin, the 2018 decision, and all of these decisions are available on Bailey, if you don't have other access to them, that is the British and Irish Legal Information Institute website at www.bailey.org. Applying the case that many of you will know of Hemming, trading as Simply Pleasure Limited and Westminster City Council, the High Court determined that local housing authorities may not, at the point of application, require the applicant to pay a fee which exceeds or indeed takes account of costs other than those of processing the application itself. Otherwise, the fee will be disproportionate to and will exceed the costs of the procedures and formalities under the authorization scheme to which Regulation 18 of the 2009 regulations refers. In short, therefore, the local housing authority cannot charge at the point of application, or cannot oblige applicants to pay at the point of application the so-called Part B fee. What therefore is the consequence of the 2009 regulations as applied by the decision in Gaskin? Well, in short, it's the requirement for a two-part fee structure. The first part comprising of a reasonable charge made at the point of application that is proportionate to and importantly does not exceed the costs of processing the application. And the second part, a further and proportionate charge payable upon the grant of an application, comprising a contribution towards the balance of the costs incurred by the local housing authority in carrying out its functions under Part 2, or as the case may be, Part 3 of the 2004 Act, and Chapter 1 of Part 4. Now, that much is, as a result of the decision in Gaskin, is now sufficiently clear. But the authorities are far less clear, I would suggest, about what the costs of processing an application of these so-called procedures and formalities to which Regulation 18 refers, what they actually consist of, and how they're to be distinguished, for example, from subsequent running and maintenance costs. Now, arguably, when interpreted against the backdrop of sections 63 and 87, the expression procedures and formalities should be read to include all of the steps that are necessary to establishing the licensing scheme in the first place, together with the costs of receiving and processing individual applications, and the so-called running and enforcement costs to include the ongoing costs of operating the scheme or the designation once it has been established, with the exception of processing individual applications. Now, that approach is arguably supported by non-statutory guidance issued by the Local Government Association in 2017 in a different licensing context, and that guidance is entitled Open for Business, which suggests that cost headings that may fall within in fact, it suggests a list of cost headings that may fall within either the processing component of the application or the subsequent component of the licensing fee. And according to that guidance, under the former component, that is processing, the cost of consultation and publishing policies can be fully recovered. If I just show you on my screen part of that guidance for a moment, you may find it interesting at the very least. Bear with me while I do that. So hopefully you should be able to see on your screen the extract from Open for Business, and you'll see that although this is given in a different context, suggests that initial application costs could include administration, initial visits, third-party costs, liaison with interested parties, management costs, local democracy costs, on costs, which are charges essentially for officers' time dealing with an application, development, determination and producing licensing policies, web materials, advice and guidance, and on the next page, setting and reviewing fees, and then further compliance and enforcement costs could include additional monitoring and inspection visits, local democracy costs, registers, and national reporting. Now, as I say, this guidance was given and made in a different context, and therefore it cannot be taken for granted that it would necessarily apply in this context. But I would suggest it does provide perhaps a useful source of information for local housing authorities who are considering how the process is approached in a different context. So as I say, that is the difficulty that many local authorities face when fee setting, is that they are required not just to determine the costs that are properly included within their license fees, but then to ensure that the first part of those fees does not include anything apart from a proportionate cost, or a proportionate fee to the cost of processing the application. Everything else has to come under the so-called Part B fee that is chargeable and can only be required to be paid at the point that the application is successful. So that takes me to the end of my slides on application requirements and fee setting, and I'm going to move on to deal in the next 10 or 15 minutes with some of the questions that have been put to me. Some of them before this webinar began, and some of them during the process. And forgive me, in a moment, I'm going to take a look at some of the comments that have been made and the questions that have been put online, which I've not yet had a chance to look at. But before I do so, let's deal with some questions that were put in advance. So the first of them: can a local authority increase its license fees partway through a designation, bearing in mind that an authority would have consulted about its proposed fees and that a designation will usually run for 5 years? Well, I did indicate that perhaps we would return to this issue later on, and this is the reason why. I'm not going to express a definitive view about that here, and certainly none for advisory purposes. But provisionally, I would suggest that in principle, yes, but it of course would depend on the circumstances. So it seems to me that in principle, given especially that local authorities are not allowed to make a profit and are expected to administer designations that are cost neutral, that a local housing authority must, for practical purposes, be able to review its fees from time to time, and if necessary, adjust them to ensure that it meets the objectives of the 2004 Act. It will, however, depend on the circumstances, I think. So importantly, the discretion enacted by sections 63 and 87 is, I would note, not time limited. If the fee increase represents a truly significant change to the authority's original proposals, such that it really changes the character of them, then the authority might need to consult about the change, but not if it's a mere modification of its original proposals, which many fee changes will be. So I think the answer to that is in principle, yes. It would rather depend on the circumstances. You may need to consider whether there's a need to consult about the change, but in most cases, I would suggest probably not. Again, a view expressed not for advisory purposes. Secondly, a number of local authorities have commented that they have issues with the application process because applicants provide the wrong information in their applications. I would only comment about that. Local authorities should remember that one of the prescribed requirements of all license applications, as a result of the 2006 regulations at which we looked earlier, is that the applicant signs a declaration that the information they provide in their application is correct to the best of their knowledge and belief. And that declaration, as you will see, if you look at, I think it's Schedule 2 to the 2006 regulations, that declaration informs the applicant that they will commit an offence if they supply any information that is false or misleading, and which they either know is false or misleading or are reckless as to whether it's so. And that offence is enacted by section 238 of the 2004 Act and is punishable on summary conviction by an unlimited fine. So in an appropriate case, you might need to take enforcement action under the 2004 Act as a result of knowingly or recklessly provided false information. Don't forget that you have that enforcement provision in your armoury. And then thirdly, could a local authority offer applicants the ability to pay both Part A and B fees up front at the point of application, provided it doesn't require them to do so and agrees to refund the Part B fee if the license application is not successful? Again, I'm not going to express any definitive view about that, and again, none for advisory purposes. But my view is that's probably right. It probably can do that, and it brings to mind the passage that I read out to you earlier from Lord Justice Bean's judgment in one of the Gaskin cases about the information requirements of the 2006 regulations. And at paragraph 37, you perhaps remember this, he says, so Richmond was not able to require the occupants of a property to be named upon a renewal application for a property in England because the 2006 regulations did not specify that information was to be provided. But he goes on to say there would be nothing wrong, however, with an application form inviting the landlord to give names on a renewal application, so long as it's made clear that this is voluntary. Well, arguably, the same approach applies to payment of the Part B fee, insofar as the local authority might say, well, look, you have to pay the Part A fee, and we cannot require you to pay any more. But in order to avoid, or for efficiency's sake, you might wish to pay the Part B fee up front. If your application doesn't succeed, that part and that part alone would be refunded. But if your application is granted, it means that we would be able to issue you with a license without any further delay. And it may be that for practical and enforcement purposes, that would be, as I say, a practical approach, because then, of course, it avoids potentially the need to chase applicants for the payment of a second fee before, as I say, the license is granted. But as I say, no definitive view about that, but that's my off the cuff, if you like, knee-jerk response to that particular question. Now, bear with me a moment while I take a look at some of the questions that have been posed online during the course of the webinar. So I've been asked about renewal applications. What if information about the mortgaging company, managing agents and tenants have changed during the renewal? Well, I take you back again to the judgment of Lord Justice Bean, where he says there would be nothing wrong. There's nothing wrong in the local authority requiring the applicant to sign a declaration that there has been no other material change in circumstances since the first application was made, and that perhaps is the easiest way of identifying whether in fact there has been a change for the purposes of a renewal application. Would it be permissible to specify the date that an HMO license runs from the date the application is duly made, regardless of when it is actually granted? Again, no definitive view, but I'm inclined to think that a license should only be granted, should only be dated from the point of grant and not backdated. And there's again no definitive view, so this is rather a knee-jerk response to the question. But a license, of course, imposes obligations on a license holder, and although it would be impossible, I would suggest, to enforce those obligations retrospectively during the period before the license was actually granted, it would probably be wrong nonetheless to backdate the application such that it appeared that the license holder was subject to them from the date of application, when that's plainly not the case. And that doesn't prejudice the applicant, because, of course, as we saw under sections 72 and 95, they have a defence to any potential enforcement proceedings if in fact an application has been duly made for the purposes of the 2004 Act. Will we be sent a copy of the presentation slides? I believe so, but I'll double check with Carolina, who administers the webinar for us. I understand that you can review under section 60, which includes increasing fees if circumstances indicate that the fees were set too low or that the scheme is not running as anticipated. That's from Balbinder. Indeed, that's right. There is, as we saw last week, an obligation under both parts 2 and 3 of the 2004 Act to review the operation of a designation from time to time. That obligation, that statutory provision, doesn't expressly mention or refer to fees, but as indicated, my inclination would be that it must be open to a local authority to review the fees that it is charging to ensure that its designation is operating effectively, as of course it has a general duty to do, as we saw under both parts 2 and 3, to ensure the effective implementation of the licensing schemes under parts 2 and 3. Again, can I have a copy of the slides? Again, I'll check with Carolina about that. Should HMO license fees be capped, particularly for a block HMO with excess of 150 units, so-called cluster flats? Well, that's a matter for the local housing authority's discretion as to whether it wishes to cap fees, but there's no requirement that it does so, provided, of course, that the fees that it does charge are both proportionate to the costs it incurs, and are reasonable. And I would emphasize at this point that a local authority cannot include costs under either part of the fees, that's part A or B, if as a result the overall fee would be neither reasonable nor proportionate. So you have to take a view about what is the not just a proportionate fee relative to the cost that you incur, but also what is the reasonable fee that an applicant should pay. Just one point further, going back to the open for business guidance and looking at, for example, IT costs. So I mentioned earlier that according to the guidance, the costs of consultation and publishing policies could be recovered as part of the Part A fee. By contrast, just by way of illustration, it might be said that the costs of IT facilities, because they're required as much for running and maintenance as they are for procedures and formalities, that the cost of them should be divided proportionately between the Part A and B fees, so that they are not all lumped into the, for example, the Part A fee. That I'm afraid brings us to the end of our 1-hour webinar today, and I know that there have been a number of further questions that have been asked. I'm afraid I'm not going to have time to get through them today, and I know that many of you also asked questions in advance of the webinar about the circumstances in which the local authority can attach certain conditions to a license. That, as I said at the start, will be covered in next week's webinar, which will look at licenses and license conditions. And I hope that that many of you who joined me last week and are here today will join me again for that webinar. In the meantime, it only remains for me to thank you once again for joining me. And as I say, I look forward to seeing you next week. Thank you very much, and enjoy the rest of your day.